Harvey Weinstein's conviction in New York was set aside by the New York Court of Appeals in a 4-3 decision. The majority decided that Weinstein had not had a fair trial because the trial judge allowed testimony by witnesses who alleged that Harvey Weinstein had sexually assaulted or raped them. And those crimes he had never been charged for, and those crimes were not the question of the trial. So the majority said this was an egregious error such that we are overturning the conviction, and the New York District Attorney will have to redo the entire case. They said the only evidence against the defendant Weinstein was the complainant's testimony, and the result of the court's rulings was to bolster the claimant's testimony and diminish the defendant's character before the jury. Generally speaking, under the rules of evidence, you cannot use prior bad acts to prove that the act in question was in conformity with those other prior bad acts. There is an exception, though, for sexual assault victims. New York has not adopted that federal rules exception, really follow this Mullenix holding, which allows jurors to consider the evidence of other uncharged crimes if it tends to establish a motive, intent, the absence of mistake or accident, or a common scheme or plan. It's hard to determine exactly where the line is of when evidence of these prior uncharged similar bad acts should get into evidence, but the New York Court of Appeals decided in Harvey Weinstein's case that it's out. So now New York needs to decide if they're going to retry him. However, Mr. Weinstein has been convicted of rape in California and sentenced to a 16-year prison sentence there. So most likely, Mr. Weinstein is not getting out of prison and will instead be transferred from New York to California to serve out his sentence. We'll let you know what happens.